You, Mr. Black? Okay, please state your name and who you represent for the record.
My name is Jim Black. I represent Angel Eyes Over Texas. We work with families, help guide them through the system, let them know what they're up against when the children are taken. My background is not in social work or law or anything else. I was a manufacturing engineer for 32 years. Did special contracting with 52 different companies. And I used my background to look at how CPS fails to use the system, how it is designed. We've heard testimony that they have all these procedures that they're supposed to follow, but the problem is departmental practice is do not follow the procedures. They are not trained to the procedures. Representative Stickman asked earlier when CPS was created. I've got a little trivia that will surprise you. It was created by the 33rd legislature in March of 1913, and the name of it was the Texas Bureau of Child and Animal Protection. This is the first biannual report. You can find it on Google Docs. But officially, as what we think of CPS, was created under the Department of Human Services when CAPTA was passed in 1973. In 1992, the Texas legislature created the Department of Protective and Regulatory Service. In the 74th legislature, the definition of DPRS was moved to Chapter 40 of Human Resource Code, and that defines the statutes that gives DPS and Family and Protective Services their authority to operate in the house. In 1997, they bumped up the sunset review for DPRS by 2 years, and SB 359 defined DPRS as a full standalone agency under Texas law. At that time, things that should have happened never took place. Investigations were supposed to be separated from social services. APS, CPS, and at that time CCL was supposed to be consolidated, and all investigations were supposed to be trained as investigators and be agency-wide. This would get around the problems we have that now we're having to deal with Judge Jack over this lawsuit where kids in foster care were not protected. One of the part of that legislation that year, Human Services 40.061, subtitle C, was added to legislation. It created the ability to nullify a caseworker's immunity to criminal prosecution. Texas is the only state that I've been able to find that has such a provision. But the problem is, it is not being enforced. Representative Rue in the 83rd introduced the independent ombudsman. Like he said a few minutes ago, Representative Duckman introduced basically the same bill this last session, but by the time they got through stripping it down as SB 830, it became an investment for only foster care, not all kids in CPS. During the Select Committee on Child Protection in 2014, the Juvenile Justice Department testified where children in JJD have both a Inspector General and an independent ombudsman. They have two avenues for protection. It's shameful that Texas protects children that have done wrong more than children that have been wrongfully, where that are victims of wrongdoing. One of the things that early on you were Chair was asking a question about money for preventative services, child drug programs and such heavy as that. Up until recently, federal money, well actually it hasn't been passed yet, but federal money is not directed that direction. That's the reason quite often we don't have the services that was necessary. 2 weeks ago, H.R. 5456 was passed by the House of Representatives in Congress. It's had second reading before the Senate, and it moves 4E funding from foster care to 1 year of evidence-based preventative services. Now we will have uncapped entitlements to actually provide preventative services to our children should it pass. It's obvious I'm varying from my
No, you're doing a very good job in understanding that it passed the House. So, why don't you give us some recommendations based on your long history and knowledge of this subject matter?
And we've been doing this about 8 years now. Over the course of that time, we have regional groups set up on Facebook for all 11 regions, so that because the agency rolls out different programs in different parts of the state at different times. So that's I did that right before sunset so that we could figure out exactly what's going on. Like I said, I was a manufacturing engineer. If you know anything about manufacturing engineers, we find problems you don't know you have it, and we solve them in ways that you cannot imagine. My recommendations, one of them is get rid of the individual offices in CPS and have law enforcement short cycle their cars and get these workers out on the street instead of being in an office. They can have special offices set up to meet with families, but why is Texas one of the only states that forces caseworkers to use their own cars? That would improve morale tremendously. Can you imagine the stress on a caseworker to have to go out and all of a sudden they have a flat tire and they have to take care of that. Another thing is I'm heavy on automation. SB 206 removed the technology mandate from statute this last session. They also removed the family preservation definition from statute, even though family preservation is still mentioned in other areas of Chapter 40. Another area is in 1997, when SB 359 was created, they created the Flexible Response System of Service Delivery. It offers 4 different methods for investigations to take, and it's designed to reduce case loads. Because of departmental practice, I have never seen any evidence of it actually being applied. I heard testimony that handbook was over 5,000 pages. We tracked all changes to the handbook on my website. It's a little over 2,100 pages before February 15th of 2015, when CPS stripped 450 pages and 670 topics of procedures, not policies, from the handbook. They are forcing these workers to rely on supervisors that have not been properly trained. Over 30 years of more than 30% turnover. The only way a corporation survives is their documentation. The only similar situation that has huge turnover is the military. When you are in the military, you have standard operating procedures handbooks. Those are orders. If you vary from that, you're court-martialed for insubordination. And that's the situation with the handbook as we see it right now. We do not see workers following it. The attorneys spoke only of emergency removal without a court order, but there's actually 3 levels of removal. Am I correct, Lisa? You have emergency without a court order, get a court order and get emergency orders, or file for a petition for a non-emergency removal. And over the course of our working with families, I have seen less than 50 instances where they went with a non-emergency removal. Almost every time it is usually emergency removal without a court order, and one of the stipulations that's built into statute on that for emergency orders is there is not time to have a non-emergency hearing. In working with these families, I would say 3 out of 5 cases did not meet the standards for an emergency removal, but the judges rubber stamped the order and moved the child directly into foster care. Not only does that put a strain on the emergency bed space, but it also puts a strain on the courts, because that forces the 14-day docket, and where they might be worried about having to wait for 2 or 3 weeks to get a non-emergency. That would move much quicker if they would actually follow due process and follow the law. And if you look at 26.061, I have an amended on the last page of my handout how I would like to see that statute amended, because once final orders are in place, basically that statute falls off to the wayside. So investigations and CCL, if this worker doesn't investigate, there's not really a way to hold them accountable.
Well, you're right. And we appreciate your testimony, and thank you for giving it to us written as well. Is there any last comments you'd like to make before I call the next?
No, just we definitely have our work cut out for us come session time. I'll be in Austin next week for the Human Services hearing, and we'll see what we can do, because we're working on very much like the conservative scorecard. I'm trying to figure out how to do a family rights scorecard so that we can find which representatives that we can work with and get this stuff moving. One other thing, At Sunset, I recommended that Sunset to be shortened to 6 years. Actually, 4 years until we straighten this out. And having correspond with judicial, do partial reviews, corresponding with judicial, community services, and then in between time, the legislature needs to leave them alone and let the stuff settle in and get things to progressing through the system much better than what they are now.
Thank you very much. Appreciate your testimony. It's very enlightening. And I'm sure,
Oh, one other
well,
thing.
I have a witness that has to leave that we invited,
okay.
and the only reason usually, let me tell you, usually chairs limit testimony to 3
I know,
minutes,
I
and
know.
I never do that. But when somebody has to leave that we've invited to testify, I think it's only respectful to allow them to do that. So we'll take